the campaign for the release of Saibaba uh, is in fact a campaign with a really long history within the civil liberties movement against arbitrary arrest and unfair trial. That has particularly hit anybody with even a peripheral um, involvement or interest in radical left movements across the country. You see this trend starting with the emergency, and it's importantly a struggle that has been carried out in courts through the writ of habeas corpus against encounters, against conspiracy cases that have been filed, against political dissidents and so on. And there have been significant victories, but also several losses, deep personal and political losses. And what is particularly saddening about this case and worrying also about this case is that this is a time when you kind of imagine that 40 years on, you have won enough ground for political dissent for this not to happen. Yeah. So for me, it's a real slide back. And really, I mean, I was in high school when emergency happened. And we always had, because my father was a lawyer, we had a lot of prisoners or torture victims who were under threat, staying in our home because they didn't have a safe shelter before they deposed. And, so what's also happened to me is, that every time there's a case like this, I just go back to what I have seen, over the past 40 years and what has happened to so many people who have been killed or arrested and have spent long years in jail. That having been said, I'm also struck by the close similarities between what is happening to Dr. Saibaba and what happened to Binayak Sen, which was the other major campaign that gained international attention. And, even with the Binayak Sen case, what also is worrying that you suddenly realize that if you do get arrested, um, then it's a real uphill task to get you out because you have investigators, you have courts, and an entire apparatus that is ideologically weighted against any form of left ideology, despite the very old history of communist movements in the country. And, Binayak's incarceration and his release, left him a shadow of the person that he was before he went into prison. And I have known him before and I know him after. It has left the family also, I'm completely, broken in a sense, in spirit, really. I mean, they're exceptionally brave and pulling together exceptionally well. But it does break you. It breaks the best of people. And so, in terms of the grounds on which Saibaba was apprehended initially and then convicted this year, there are, a lot of reminders of what we have just witnessed with the last international campaign that we had with Binayak Sen. But, what is additionally worrying about Saibaba's case, and this is something that I have been, in fact, saying right from the time he was first arrested, before he was convicted in 2014, which is that being a person with severe and multiple disabilities and related health conditions, should he be in prison at all? You know, if you suspect that he has a certain complicity in a left ideology, which is not banned, or he belongs to the Revolutionary Democratic Front or whatever, which is not banned, uh, uh, and you believe that he is supporting Maoist activity in Chhattisgarh, whether you have the evidence for it or not, it is a suspicion. But nevertheless, if you think that that is the side of the border between legality and illegality that you draw as a state actor, uh, do you actually need to apprehend somebody with severe disabilities in order to investigate the case and then keep him in solitary confinement? So when he was arrested in 2014, within weeks of his arrest, I wrote saying that this is completely unacceptable by international standards of disability rights, which we didn't have 40 years ago. It's also unacceptable by the standards of India's commitment to disability rights. And I still think that that is the strongest ground for his grant of bail. Uh, because the other grounds, in terms of his political affiliations or political convictions or his agency, or his alleged, shall we say, his alleged agency with Maoist activity, is something that he shares with 5 other people who are in the same jail on the same charges. Yeah. Uh, but they are not people with disabilities. So the impact of that incarceration on them is very different from the impact of that same incarceration on him. You know, and I think that it is about the consequences. It's not merely and the reversibility or irreversibility of the consequences. Yeah. But what I have also found is that in 2014, even 2015, even the human rights movement in India was not willing to think about disability as a legitimate ground to ask for his release, because disability rights uh, is not seen as a political uh, articulation of rights. And so there was this doubt that maybe if we plead that he is disabled and hence should be released, we are compromising with our politics, or it is an apolitical route to asking for liberty. That was the question, in fact, that was raised. And I come from a very different point of view, you know. For me, there is nothing more political than liberty. And if there is a ground, and litigation is about strategy. And if there's a ground that seems strong enough for you to be released, then that is the political ground. You know, and then you argue the actual grounds, the criminal charges you argue while you are at liberty. You know, but you don't kind of throw away an opportunity. So what happened was a very odd kind of slippage, where the human rights movement and the defenders of Saibaba kind of were not willing to concede that disability was a political ground. And on the other hand, you had a very incipient young disability rights movement for whom the shadow of Maoism was too heavy a burden to bear, because you might then invite surveillance by the state. Yeah. So in that period between 2014 and 15, neither the disability rights movement nor the human rights movement foregrounded Saibaba or disability in the campaign. After his conviction, and subsequently, of course, it went to the Supreme Court for him to get bail. And the Supreme Court did say, what do you lose by keeping him at liberty? If you have finished your investigation, you have all the information that you need, there is no reason to hold him in custody. Yeah, this was in 2016 and he got bail. But in cases that normally take years, in less than a year, he was convicted to life imprisonment along with the others, basically on grounds of his complicity with Maoism. And if you look at the judgments in the bail in December 2015, or even the judgment now, or the trial court decision, the irrationality of judicial reasoning really strikes you, because there's everything from he's physically, you know, disabled, but mentally he's very active, and so it is his mental abilities that make him complicit and he needs to be held in prison. Or Arundhati Roy has defended him. This was the December 2015 rejection of bail by the Nagpur bench. Arundhati Roy has defended him. And she needs, I mean, that was not even an issue before the court. But the judgment actually says she needs to be held up for contumacious conduct. So it is, and that is what is worrying about the incarceration, which was not really the case in the post-emergency, and the emergency imprisonments, because there you still had a fair number of magistrates and people in original courts who went by the letter of the law, even if they were against you politically. They were very correct on their criminal procedure. And if they didn't have the evidence on record, then people got released. So all of those conspiracy cases resulted in zero convictions, at that time. But we are not at a time like that now. And, that is really what is worrying. But in fact, I had written about it then. I had also submitted a letter petition to the Supreme Court that still hasn't got called up. And now he's faced conviction also. But and then I was kind of silent, because you do have a defense committee that consists of the teachers of the Delhi University Teachers Association. You have independent intellectuals like Professor Hargopal. You have Anand Teltumbade. You have a lot of people who are actually involved in the negotiations with public authorities, in supporting the lawyers. He has extremely competent lawyers. Rebecca Mammon John is one of the best criminal lawyers we have in the country. She was the person who got the Talwar couple out, of jail. Mr. Gardling, who is defending the Saibaba in Nagpur, is also an extremely competent lawyer. And between Rebecca and Gardling, I think they're doing a marvelous job. It's also, of course, anxiety. A person is in, you don't know whether the person's going to be out or not, and you feel you need a high-profile lawyer. So I think at some point, some members of the defense committee went to appeal to Ram Jethmalani to appear for Saibaba. Now, for me, that's completely counterproductive, because what Ram Jethmalani's own ideological orientation is. But of course, he kind of had them going around for a bit and then said he won't do it. But I think, and there was some anxiety about whether he has adequate legal representation. And I do want to state this very clearly on record, that he has, these may not be your high profile lawyers who are in the media all the time, but they are extremely and possibly among the most competent lawyers that we have. And they are putting themselves out at no cost to actually provide him with the best legal services that are possibly available in the country, both in Delhi and in Nagpur. So on that count, I don't think we need to worry too much. They have a strategy, of course, which is in terms of the grounds on which he is arrested. Since there are 6 people, 5 people along with him, who are facing similar charges, the bail applications will have to be sequenced strategically. So there are 3 Adivasis, there's a journalist, and Saibaba. All of them are in prison. And so you then have to see which is the surest case to get bail. And so there has to be a strategy, and which will then ensure that you get bail first for one and the others will follow. And that is a closed decision that we must leave to the lawyers. So I think in terms of public intervention, we also need to recognize to what extent intervention is okay, and at what point we must leave trust and decision to the lawyers. Because here you do have lawyers with a human rights record and who know what they're doing. Uh, and that sequence or those decisions will have to follow if you follow the route of the criminal case. So you can't, for instance, go to the lawyers and say, don't file a bail application for A, file a bail application for E first. That is a decision that they will have to take, whether they go all of them together or one first, whether Saibaba is first or last, is a strategic decision that the lawyers will take. The possibility for Saibaba actually to be out is, to my mind, uh, on the fact of his disability. Now, by 2016, even the Defense Committee had started to assert that he's a person with 90% disabilities and he needs to be out. But by then, the things had got set. The rhetoric had got set. So it became a little difficult and late in the day to bring that element in. It should have been come in. But we kind of learn as we go along. And now there is an assertion that he must, the fact of disability must be taken into account. But also, a couple of months ago in India, we had a 9-judge bench asserting that the right to privacy is a fundamental right. Yeah. Now, my interest has been to see what are the ways in which we can argue various parts of civil liberties within the right to privacy, because each will have to be argued separately. So there's no jurisprudence on the right to privacy post judgment that we have. We have something they've relied on earlier, but after the judgment, there has been no decision that's relied on the right to privacy. So I've kind of looked at it for different cases, in the case of transgenders, in the case of free speech, and that's when Saibaba saw the article and actually wrote me a letter less than a month ago from the jail, detailing detailing the case, detailing his case, and talking at great length about what were the irregularities in the trial, what were the irregularities in the calling up of witnesses, how the choice of witnesses was deeply fraudulent and needs to be interrogated, and how, despite evident illegalities in the various elements of the trial, they have still been convicted. So he kind of goes through and this is really the first account that I read of the minute details of the case, of each punch witness, who is he, how is he an illegal witness, what happened to the evidence, when the computers were confiscated, what did they find on the computers, where was the evidence sealed and signed by the confiscating authority, and you find that that has not happened. So there are all of these irregularities that happened in the course of the trial that he's kind of detailed for me, basically asking if I would write something on his case. But I find that it's not, whatever I write will be for a newspaper 1100 or 1200 words, and I can't go into the minute details of the case. And also the minute details are with the lawyers, and these are minute details in the criminal trial that have to be argued in court. You and I can't actually make sense of, can't really make sense of where to take this information. We can tell each other about it, but we don't have the locus standi to actually present this information to court. So the information is with the lawyers. But in terms of the possible explanations for his coming out, I still think, and I've also talked about this to Rebecca, one of his lawyers. I still think that the best bet is to argue that the infringement on his right to life and bodily integrity and dignity is disproportionately larger than the infringement of the right to bodily integrity and so on of a normal person or an able bodied person. Having handed over the whole thing on a platter to the BJP, I think the current government has just completely tightened the stranglehold and not left any leeway for a different articulation. Yeah. And this is really the moment for courts to snap out of the captivity of the executive. You know, we are talking about the separation of powers. The court cannot speak the language of the government. You may very well, in your personal life, be a sympathizer of the BJP and might vote the BJP in, but when you're on that bench, you are a judge. And it is your constitutional duty to separate yourself from the executive. Yeah, that is something that is only happening in fits and starts. If you look at the Nagpur High Court rejection of Saibaba's bail application in December 2015, you will see exactly what I mean. Because the judge is actually saying things like, you know, Arundhati Roy wrote against Operation Greyhounds, wrote against the government here in Chhattisgarh, and she talked about how the government is actually, guilty of causing harm to Saibaba and so on. I mean, very detailed kind of malicious account of what Arundhati Roy did and how she's complicit, and urging the government to sue her for contempt. Yeah. Now, if that is any indication of which way the bench will go, because both his bail application and his appeal against the trial court conviction is in the same court, then whether or not the judiciary is separate from the executive is a big question. And for me, that is the biggest casualty, in the way we are going. Because the privacy judgment tries to do precisely that. It tries to assert that the judiciary must be separate and dispassionate in its consideration of fundamental rights. Judge Loya was a judge in the CBI special court that was hearing the Sohrabuddin and Kausar Bibi encounter case, in which the BJP National President Amit Shah is an accused. And this case was shifted out of Gujarat to Maharashtra because the environment in Gujarat was not conducive to the holding of a fair trial. And that's a provision that you can actually ask for a trial to be shifted to another state if you believe that the process of justice will be obstructed in the home state. Now, Judge Loya was appointed to hear this case. Prior to him, there was somebody else. And when the earlier judge called for Amit Shah to come and depose, he was transferred. And Judge Loya was brought in. And of course, Amit Shah did not depose, and he was meant to appear before Judge Loya on December 15th. And there are several accounts that Judge Loya, these are accounts that came up after his death, of course. What basically happened was that December 15th, the Shah was supposed to depose before Judge Loya. On November 30th, Judge Loya goes to Nagpur to attend the wedding of his colleague's daughter. And on the morning of November 30th, his wife and his father received calls saying that he has died of cardiac arrest. And the body is sent to their native place. They're not asked where the body should be sent. They're just told, you come reach your native place. And the body is sent there and he is cremated. 2 years later, there is a story that, 3 years later, there's a story that breaks out by a journalist who has spoken to Judge Loya's sister, and both his sisters, one of whom is a doctor, and his father. The wife and children refuse to speak to the journalist. But what actually comes out is the fact that Judge Loya has no history of a heart complaint. But okay, you can die of a cardiac arrest suddenly. But there were very discrepant accounts of what happened to him. Considering he died a natural death, there was a post-mortem that was conducted. There was no post-mortem report. His belongings were not sealed. There has to be a panchnama, and the belongings have to be sealed and signed by the officer. There was no panchnama done of his belongings. His phone was handed over to an RSS worker in Nagpur, who returned it to the wife 1 week later with all the call records deleted. And then there was nothing, no post-mortem report that was given to the family. His body had just been cut up and sewed back, and the family had his. And then the family also said that his body had been sent unaccompanied in an ambulance to the native place, and the family received it. And this story broke out, and it created quite a furor. I mean, it was all over Twitter and Facebook and everywhere. The journalist is, of course, under threat. And later, the judges who had been named, and apparently the two judges who really persuaded Loya to go for the wedding did not condole the family till almost a month later. And about a week later, you had the hospital where Loya had been taken to came up with an ECG report and said, no, there is an ECG report of his condition. And the ECG report was dated the previous night when he died in the morning. The wrong date on the ECG report. And there were judges who came and said, no, there was no irregularity. There were reports that the family was under pressure to retract its statement. The son had also reportedly said that the father had been offered some crores of rupees in order to, just back off from asking Amit Shah to come. The Chief Justice of Bombay High Court in 2014 was named as one of the people who tried to silence Judge Loya and ask him to back off. So it was an account of judicial complicity in the murder in the alleged murder of a judge who was asking for the national president of the BJP to be brought to court to testify. Yeah. You could, of course, say that there is no substance. But when there is an account like that, you can't say there's no substance without investigating it. So the question for me is, you may have asked the son and the wife to retract the statement. They might have retracted the statement. That still doesn't leave, that still doesn't get rid of the accusations that were made of the entire event surrounding his death, which itself calls for an investigation. Because again, it's not now so much about Judge Loya, but about the institutions of the judiciary. both right from the trial courts to the High Court. And that is what is worrying, because these are the institutions that we are going to go to if we fall foul of the government tomorrow. Yeah. And what is the sense of security you have as a citizen if you can see that the institution is crumbling before you, and that there isn't a voice from within the institutions that says, no, let's shore it up and let's kind of resurrect it? I mean, but Justice Loya was not scared. He was not scared. It's a very peculiar moment. Justice Loya is not alone and dying. What we have is a continuum of death, from the street to the judiciary and political opponents. It's just, you're not safe anyway, anywhere. There is a complete intolerance of any dissenting viewpoint. So you have Gauri Lankesh, you have the lynching in Rajasthan last week, you have Mohammad Akhlaq, you have Judge Loya, and you will have many more. But the bodies will stop dropping like that only if you just set out the non-negotiable. But if you keep capitulating, you're just piling up the dead. And that is really what is most worrying. One, of course, is, yes, there is this person. He is a political dissident. He's in prison. He has profound disabilities. He needs to be out. And you should not cause him irreversible harm. So, and you have a plethora of case law that talks about treatment of prisoners with dignity. But that's one part of the problem. The other part of the problem has to do with what does that negation of his rights do to the judiciary vis-a-vis an extremely repressive and right-wing state. Because really there are mobs on the prowl. I mean, you're not safe. So, yeah.
So you feel there's still a possibility for kind of that kind of judicial activism?
I think so. I mean, if I didn't think so, then, I might as well be the next body dropping, no? There has to be, I mean, I'm really hoping, because even with Judge Loya's case, the fact is that there are, of course, people in the judiciary who've been complicit or in their silence, or who've turned the other way, or who are not talking. But there are other judges and retired judges. Justice Shah spoke out about it. There are people who are talking. There are journalists who are writing about it. You may be trolled. There may be a lot of effort to silence you. But at least you're speaking and writing, and you are hearing that, also the fact that his son later, Judge Loya's son later asked for, withdrew his demand for an investigation into his father's death and so on. Nobody bought that. It wasn't like people said, oh, the son has, that means nothing has happened to him because the son has taken back his request. Nothing really happened. Nobody is saying that. Everybody is saying, look at the pressure the boy's been put under, or look at the pressure the family's been put under. So, I do think that also my own sense of conversations of people is that people who were kind of quiet and not vocal on any aspect of politics or whatever, you can actually hear a murmur that says this is not okay. And in a way, Judge Loya's death is a tipping point. The disclosures around his death.